A very warm good morning to all of you. Dear students, once again, I would like to welcome all of you to a new session of the Civics class. Today, we are continuing with the same chapter from Civics, chapter number 4, the Supreme Court, part 7. Do you remember what we were dealing with in the last few number of classes? We were discussing on a particular concept, that is jurisdiction and powers of the Supreme Court. Under this title, we were focusing on a concept, that is jurisdiction. What is meant by jurisdiction and what were the different types of jurisdiction. And we have already completed the first type of jurisdiction, that is original jurisdiction. And in the last class, we have seen the first part of appellate jurisdiction. And under appellate jurisdiction, we were discussing about one particular concept, that is constitutional cases, or how appellate jurisdiction imply or how appellate jurisdiction functions on constitutional cases. And today we are going to discuss the remaining two different factors. They are civil cases and criminal cases. So here we are going to see how appellate jurisdiction imply in civil cases and criminal cases. So without wasting time, let's move to the class. Constitutional cases, we have already discussed it. We have completed that particular part in the last class. And today we will be continuing with the second point, that is civil cases. How appellate jurisdiction function in the case of civil cases. Appeals in civil matters lie to the Supreme Court if the High Court certifies that the case involves a substantial question of law of general importance. So first of all, appellate jurisdiction in the civil case will take place once the High Court feels that in that particular case, the substantial question of law is involved, or the interpretation or a special question is needed, which beyond the jurisdiction of the High Court. So in such case, with the consent of High Court, that civil case can move to the Supreme Court, and that the question needs to be decided by the Supreme Court. Suppose in certain cases there can be such a situation that that particular case will be coming to the court maybe for the first time, and even the experts in the High Court or the subordinate courts, they may not be having enough idea about what must be done in those cases. That's what is meant by substantial question of law, or the central government has implemented a new rule, so there will not be much interpretation and explanation about that particular case or that particular law and its different subdivisions. So that's why that case must be referred to the Supreme Court. So that's why it is meant like if the High Court certifies, if the High Court feels that case involves a substantial question of law of general importance and that question needs to be decided by the Supreme Court. So in such cases or in such matters, that case will move to the Supreme Court as an appeal. If the High Court refuses to give a certificate, the Supreme Court can grant special leave to appeal in suitable cases. Suppose in certain cases, if the High Court is not giving the certificate, there the Supreme Court can use its special power, which means special leave to appeal, by which we can move to the Supreme Court for getting justice. So that's about the civil case. I think it's very clear to you. The High Court will be giving a certificate because the High Court may not be able to deal with the case just because there is a substantial question of law, and the question, what type of question it must be, it is decided by the Supreme Court. In such cases, normally High Court will be referring that case to the Supreme Court. Or suppose if the High Court is not giving a certificate, in such cases, the Supreme Court can call or Supreme Court can grant special leave on leave to appeal in suitable cases. So this is what is happening in the case of civil cases. Now let's see the next point, that is criminal cases. Two types of appeals in criminal cases lie in the Supreme Court. So generally there are two different types of criminal cases on which we can go to the Supreme Court for appeal. Suppose if we haven't got justice from the High Court, we can approach the Supreme Court in two different situations. First one, cases without the certificate of the High Court. Suppose if the High Court is not giving the certificate. So that is the first category. And second one, cases with the certificate of the High Court. So these are the two different types of appeals in criminal cases which we can take to the Supreme Court. The certificate of the High Court is not required in a case. So here there are two different kinds of cases in which certificate of the High Court is not needed. First one, where the High Court has reversed the judgment of acquittal given by the lower court and punished the accused with a death sentence. I read it once again. Where the High Court has reversed the judgment of acquittal given by the lower court and punished the accused with a death sentence. Suppose just imagine a case came in the lower court or subordinate court in which the lower court released the culprit, but when the case came to the High Court, the High Court has cancelled, reversed the judgment, cancelled the judgment of the lower court and punished the accused with a death sentence, capital punishment or sentence to death. So in such cases, even without the certificate of the High Court, we can move to the Supreme Court with the appeal. So I think it's very clear to you. Where the High Court has reversed the judgment of acquittal given by the lower court and punished the accused with a death sentence. And second situation is a case which is withdrawn by the High Court from a subordinate court and sentenced the accused to death. So generally we can say the High Court is not having the power to declare or sentence the accused to death. Capital punishment is not coming under the jurisdiction of High Court generally. It doesn't mean that they cannot give, but certain limitations are there. A case which is withdrawn by the High Court from a subordinate court and sentenced the accused to death. So these are the two situations where even without the certificate of the High Court, we can approach in the Supreme Court for getting justice. In all other criminal cases, a High Court certification that the case involves a substantial point of law and interpretation of the Constitution is required for appealing to the Supreme Court. So these are the two different situations where we can approach the Supreme Court for getting justice even without the certificate of the High Court. In all other criminal cases, High Court must give a certification. Or there are certain cases where certification is not needed if it involves a substantial point of law and interpretation of the Constitution is required. We have already seen what is meant by substantial point of law and interpretation of the Constitution when we were discussing about the original jurisdiction, because only Supreme Court is having the power to interpret the Constitution and explain about the substantial point of law. So in such cases, if a case, whether it is big or small, whatever it is, if there is a substantial point of law and interpretation of the Constitution is required, we can move to the Supreme Court for getting justice with the appeal. In other cases, all the criminal cases will be coming to an end in High Court itself. In all other cases, if everything is very clear, the decision of the High Court will be final. We cannot move to the Supreme Court. Dear students, these are the points we are discussing today. I just want to share with you today. With this, we are winding up today's class, and in the next class, we will be discussing about function of the Supreme Court, and how the settlement of disputes take place in the Supreme Court. So, still we meet in the next class with the new points. I would like to sign off. Thank you.